Oh, it's lots of pages. All right, let me hold this for a minute so I can go through that. I did not see it. I said, no, you did. Well, I can't do stuff this minute. I need, if they're gonna do a response, I need it before. No, it's not you being sorry. I don't need to. This is Mr. Coleman's case?
Yes, sir.
Are you prepared to argue?
Yes, sir.
Okay, I'm not gonna, I mean, this was filed this morning, so I'm not gonna take. Come on back up. Let's just do it. All right, so you're Larry Fletcher Jr.?
Yes, sir.
And this is cause numbers 25 DCCR 0838 and 0839. Mr. Fletcher's charged with aggravated assault with a deadly weapon and manslaughter. There's a motion that has been filed to modify the conditions of bond. That he cannot operate a motor vehicle. And so, Mr. Gertz, go ahead.
Judge, I think you're familiar with the facts of this case because we had a hearing on a motion to revoke probation. And the issue in that hearing was about causation of the accident. And the court decided that the issue was serious enough to hold that in abeyance pending trial of these two cases. And my request here is based on the fact that Mr. Fletcher has been following all of these bond conditions, following the rules the court set, but is having difficulty getting to and from work and doing other things that he needs to be doing to be a productive member of society. And he's not allowed to drive. And so, this was not an alcohol, like it's not an intoxication manslaughter case. It's just a manslaughter. It's just an allegation of reckless driving.
The problem is the history of reckless driving. And so what the state has provided, it looks like, is that there was a 2010 non-injury crash, 2012 non-injury crash, a 2012 maximum speed limit issue, 2013 speeding over 10% over the posted, 2016 speeding greater than 15 miles over, 2018 a non-injury crash, 2021 a non-injury crash. Based on my knowledge, what was presented at that hearing, regardless of causation, there was definitely a speeding issue. That was clear from the black box in the testimony, that there was a large speeding issue. And so I am not inclined to change the bond. Mr. Nichols, does this?
That was the basis of the state's argument, Your Honor, was that his history of crashes and of speeding poses a danger to the public, and that's why we were opposed to altering these conditions.
Yeah.
Judge, we were just alerted to all of that at the same time the court was, that was filed Friday afternoon at 4 o'clock. So.
Well, it is what it is. If there's something in there that you find that is not accurate, then just let me know, file a supplemental motion. But at this time, I'm going to deny the motion to modify the bond and conditions. We'll get it set. It's already on the trial docket.
It is, Judge.
All right, it'll go back right on the trial docket. And again, if there's something that's changed that's not correct, let me know.
Okay, and I think Mr. Coleman has filed a supplemental motion to revoke probation too, which will have to be heard at some point because we're going to plead contrary to that as well.
We'll go over any motion to revoke after.
He may not have filed it yet. He may have just told me he was going to file it. But.
So. That the only two cases are on here are the trial cases, not the motion to revoke cases on our docket, correct? Yes. Okay. All right. If something comes through that I need to hear, but my thought is still to go forward with the trials first and then to deal with the probation.
I understand.
Unless there's something else significant, another new case or something.
I'm not aware of anything, Your Honor.
Okay.
Well, and let me back up and say, it's not a new case. In the wake of the motion to revoke probation hearing, Mr. Coleman filed a federal case relating to the
gun that was found.
Yeah.
Okay.
So and he's not a convicted felon, but we'll argue that when it's time to argue that. But that's what the new case is.
Okay. That was something that I've already heard in that motion to revoke to some extent.
Correct. Yeah.
Okay. All right. We'll see you back at the trial date then. Good morning. Are you Leandre Simi?
Yes, go on.
And this is cause number 23 DCCR 0628. Mr. Simi's charged with criminally negligent homicide, a state jail felony. And what is the announcement?
Judge, this was a case that was on the trial docket here and then got moved to the drug court at some point, and then now, without talking about the details, it's been brought back to this court.
Right.
So our request would be, Ms. Malfino and I may be able to work this out at some point, but right now, with his immigration status, et cetera, it's necessity that we try this case.
Judge, I know that it's very old. It may be a discussion if the court would allow it. We can have off the record in the back whenever it's convenient for you. I understand the reason it came back. There are a few things I'd like to about that too. Before we just pop it right on the trial.
Okay, that's fine. Could we maybe then put it for review in 3 weeks or something?
Yeah, let's do that. Let's do about 3 weeks and a reset on a review, and you guys.
Can it just be a review that he has to come all the way in from Florida? So is it the kind of thing that we could do a review and just note that he doesn't need to come from Florida, or does he need to come back for that?
Well, if we're going to put it on the trial docket at that point, I'll need a rejection. So I don't know if y'all want to
We've done a rejection previously, I believe, Judge.
see.
You don't see it? Yeah. It's not,
Because of the expiration.
But they also, yeah.
it's fine, Judge. He'll comply with whatever. I mean,
I can do 4 weeks. I can do a normal reset if that
That's fine.
helps. And then let's just do a normal reset, and then we'll get all on the same page on that date. Okay?
Thanks, Judge.
All right. All right, ma'am, you're Ibriana Bell again, correct?
Yes, ma'am.
And we've already gone through that she entered a plea of guilty. Well, actually, let's go back because I don't even think I went too far with all of that. Will she waive the formal reading of the indictment?
So
So, Ms. Bell, in cause number 25 DCCR 1610, you're charged with the state jail felony offense of theft of property with previous convictions from August 14th of 2025. And how do you plead to that charge? And then your indictment alleges that you were previously convicted of theft of property April 7th of 2021. After that was final, August 16th of 2021. And then after that, November 10th of 2022. And are those true or not true?
True.
Did you enter your plea of guilty and true to those allegations freely and voluntarily?
Yes, ma'am.
And did you plead guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimler?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And what is the agreement that you guys have reached? And is there any issue with me changing the agreed punishment recommendation page to reflect it?
Your Honor, we've agreed on a straight probation of 2 years in state jail, probate over 3 years with a $500 fine, $221 restitution.
Correct, Your Honor.
And I have no objection to the court making those changes.
That's the current agreement, Your Honor, as reflected in the altered or corrected punishment recommendation, agreed punishment recommendation.
All right, so what the agreement is for a 2-year term in the state jail prison, that would be probated for 3 years. You would be ordered to pay a $500 fine as well as restitution in the amount of $221. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No, Judge.
It's admitted. Is there any evidence that Ms. Bell is not competent?
No, I'm aware of it.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That's going to give me more information about you, your case, your history, and then we'll come back later for sentencing.
Yes, ma'am.
You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right over there.
Yes, ma'am.
All right, we'll see you back at sentencing. Miss Bell. Hey, Miss Bell, come back for a sec. If I test you this morning, you gonna have anything in your system?
No, ma'am.
Okay, let's double check that. Okay, have a seat right over there so I know for sure. All right, so you're Justin Payne. And Mr. Payne, in cause number 25 DCCR 1358, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon. And that's from September 5th of 2025. And what that means is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 20 years in prison. Do you understand? And I have here on the tablet a plea bargain rejection that you've signed with Mr. Kimler that shows that
Today's hearing was a powerful reminder that courtroom decisions are rarely just about one moment. They're about patterns, accountability, and consequences. We watched a defendant lose the chance to regain driving privileges because of a long history of dangerous behavior, another defendant reject a major plea deal despite serious prison exposure, and a shocking courtroom drug test situation completely derail a sentencing hearing in real time. Throughout the session, the judge repeatedly emphasized one thing. Once a case reaches the trial docket, the courtroom expects action, not delays or excuses. These moments show how quickly freedom, probation, and plea opportunities can disappear depending on a defendant's decisions both inside and outside the courtroom. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns and real legal drama every week.
It shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty. For a 10-year deferred probation, there would be a $500 fine. You have every right to reject that. I just want to make sure you understand what the possible consequences are if you go to trial, what your options are if you wanted to enter a plea of guilty. And do you understand all of that? Speak up.
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes.
Is there any reason, Mr. Smith, for that you know of that offer would change?
Judge.
Any evidence that you're waiting on? All right, so I want to make sure you understand, Mr. Payne, that after today, I will not accept this plea agreement unless there is new information that your attorney or the district attorney doesn't have right now. So if you want to go to trial, we'll get your case set on the trial docket. We'll let a jury decide. I just don't want you to place it on the trial docket thinking that somehow it's going to go away or it's going to get better offer. Do you understand?
Alright. Always a chance.
Well, I mean, it can get dismissed, but that's not on the table right now, and I won't accept this later. You understand? And do you want to go forward with setting your case for trial? All right, we'll get it set on the trial docket. Stay in touch with Mr. Kindler. He'll begin preparation for trial, and we'll see you back on the trial date. All right, this is cause number 25 DCCR 1253. Mr. Wars tested positive for THC, methamphetamines, amphetamines, and ecstasy MDMA. So we are here on a sentencing. Obviously, he's not in a position today to understand the sentencing. So what I'm going to do at this time, I'm not going to reject the offer. There might be some things still that would be considered because of the nature of that offense with the probation, but I cannot obviously do it with his current state of mind. So I'm going to revoke Mr. Wars' bond based on the nature of the offense, which is a driving while intoxicated third or more. How'd you get here today? You got a ride or you drove? Okay. So I'm going to revoke the bond. At this time, there will be no bond. I'm resetting the case till next Monday for sentencing. And then I'll decide at that point whether or not I follow the agreement. And if so, Tuesday, he'll be in custody Tuesday. I'll reset the case for next Tuesday for sentencing. And then if I go along with the agreement, I'll figure out what additional conditions, which I already had
PSI recommended ISF.
ISF already, but it might be something a little more lengthy than that. Go with the bailiff. Thank you.
Judge, I can get with the counselor to let her know about today
Okay,
and see if there might be.
something different. It was ISF substance was recommended, but just based on this, he's obviously in a terrible position. He tested positive at the PSI as well. So maybe safe P would be something that would be a little more
Or a nap.
a long nap. He's about to get a nap. Miss Bell, come on back up.
Yeah, have a nice day.
Everything okay?
Yeah, I'm not even in my system.
No, you don't, but you also don't have a bad attitude about me checking, okay?
Yes, ma'am.
I check it different people for different reasons. There's no reason to have an attitude. And there's definitely no reason to have an attitude with the nice lady that's standing behind you.
I have attitude.
Okay, all right. So you tested negative, that's great. And so I'm going to reset, I can't remember now what we were doing on your case, but
Yes,
okay. Stop and talk to probation on your way out and we'll see you back at center. Cause that's very important that you're here on time.
Yes, ma'am.
I know you're driving in, but it's, your bonds were forfeited and obviously you don't want to go to jail for being late. I'm going to recall that. Your case is set for trial, for next Monday. Mr. Gertz was already here and, you need to stay in touch with his office because I'll number the cases tomorrow.
Yes,
But in all likelihood, you'll need to be back next Monday at 1 o'clock for your trial.
yes, ma'am.
Okay, you're free to go.
Thank you so much.
Good morning, sir. You're John Tat Taylor.
Yes, ma'am.
This is cause number 25 DCCR 1427. Mr. Taylor's charged with fraudulent use or possession of credit or debit cards. And Mr. Reynolds, what is the announcement?
Judge, we received the discovery of his case. He lives in Fort Worth. He has not been by my office so I could review it with him. I received an offer from the district attorney. I don't want to reject the offer till I'm able to go over that with him and ask maybe for a 30-day reset. Let us get that done.
So, Mr. Taylor, I'll reset your case in normal reset, which is about 30 days. You need to make an appointment and visit with Mr. Reynolds before that next court date. If you can do it while you're in town, great. If not, you're going to have to make a trip to come visit with him so that we can know what to do with your case next time. Okay.
Yes, ma'am.
All right. You're free to go. Thank you.
Okay, thank you. Thanks, Judge.
Your Honor, my apologies to the court. I was in the 245th for a family law trial that happened.
All right. Thank you. Thank you, sir. And ma'am, you're Deshaun Robertson. This is cause number 25 DCCR 0914. Ms. Robertson is charged with aggravated assault with a deadly weapon. And what is the announcement?
Yes, Your Honor, we have no announcement today. However, we're requesting a push from the court to give a mitigation packet to the prosecution in this case.
What do you mean a push from the court?
An extra date.
I think a reset, Judge. Mr. Naismith has advised me he is preparing a mitigation packet for Mr. Nichols and would like to sit down with him and discuss in person some things that may change the offer. The offer now is a pen time offer, not a probation offer. There is a cap made in the case. So I don't know that mitigation packet may either alter the offer or help Luke explain the cap to counsel.
Okay. So what I'll do, it looks like you filed a notice of
This exchange right here is one of the most revealing moments in the entire hearing. The defendant is turning down a plea offer that could keep him out of prison through deferred probation, but the judge makes something crystal clear. Once this case moves to trial, the deal is basically gone unless completely new evidence appears. And that warning matters. A lot of people assume plea deals will still be sitting there later like a backup plan, but judges hate gamesmanship when it comes to trial dockets. The moment she says, "I won't accept this later," you can hear the seriousness in the courtroom shift instantly. And then comes the defendant's response, "Always a chance." That one sentence says everything about his mindset heading into trial. Confidence? Optimism? Or underestimating the risk? Let me know in the comments. Would you gamble on trial facing up to 20 years? Or would you take the probation deal while it's still on the table?
Filed a notice of representation back in December.
Yes.
So this will be the final reset for an announcement.
Yes, Your Honor.
And so on that date, either it gets taken care of with the plea, or at that point, there'll need to be a rejection of any offer and it'll move to the trial docket.
An announcement that day as well. Rejection announcement that day too.
Yeah,
Well, I've
that,
explained to him when it goes on this course trial docket, it is intended to be a trial.
yes. Yeah, there's no putting it on the trial docket and it not going to trial. It either goes to trial, or if there's some different negotiation, it would be because there's new information. I don't take the plea agreement after that date.
Yes, Your Honor.
So once it's on the trial docket, it's either a trial, or if it's something different, it's because there's more information that's for some reason y'all didn't know.
Yes, it was a HIPAA release. I took care of that 5 days on that.
Okay.
For a mitigation packet, I'll get it to you.
Okay, sounds good. Then we'll just do a normal reset. Obviously this should have been taken care of quite some time ago. I know Ms. Holmes sent you an email back in April.
She did.
That we needed that. So there will be no reason, that cannot be a reason for another reset.
It's not.
I'll get that signed today for that investigator, but it won't be a reset based on that. Okay.
Yes, Your Honor.
All right. Stay in touch with your attorney. He'll let you know when you need to be back.
Yes, Your
All
Honor.
right. Thank you.